On.
Okay. Attorney Fernandez, are you here? Wala sa desk niya. Attorney Fernandez.
Yan na.
Wave.
Attorney Fernandez.
Attorney Fernandez. Wala.
Ayaw na.
Iba.
Attorney Leia, I'll call her.
Siya ba yun? Siya yan?
Staff
Hindi
po niya.
yan.
Si Judge Galvez po. Judge.
April, are you there?
Di ba Fernandez muna?
Ay, opo, sige.
Yes
Attorney
po, Attorney
Fernandez.
Gal, I'm here po. Please call. Yes po, I'll call Attorney Vicky Fernandez. Yes, thank you.
Si Judge Galvez po joining po ulit for the oath lang po, and then we will put Judge Galvez in the waiting room po. Kasi the first one to be interviewed is Attorney Vicky Fernandez. Ayan, Judge Caridad Galvez is here waiting for Attorney Vicky. Sumagot na, Miss April.
Nawala yung
Ayan, si Judge.
nawala dun sa isang point. Sorry.
Can we
live sa
put on mute mode first, Judge Fernandez, please, Glenn? Attorney Fernandez. Yan, nandito na po siya. This is her secondary device. Can we put on spotlight mode there? Thank you. Attorney Fernandez and Judge Galvez, good afternoon. The honorable members of the JBC are here already. We will now begin the interviews. Again, I would like to remind your honors that this will be streamed live in December. So tape as live po tayo ngayon. PIO, if you're ready, we go live in 5, 4, 3, 2, 1.
Your Honors, good afternoon.
Afternoon.
This is a continuation of the public panel interview by the Judicial and Bar Council of candidates for the position of Associate Justice of the Court of Appeals, the Court of Tax Appeals, and the Sandigan Bayan. The candidates for interview this afternoon are the following. Attorney Vicky C. Fernandez, candidate for Associate Justice of the Court of Appeals, the Court of Tax Appeals, and the Sandigan Bayan. We have also Judge Caridad V. Galvez, a candidate for Associate Justice of the Court of Appeals. May I request the candidates to please raise your right hand so that I can administer the oath. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
Yes, I do.
So help you God. Thank you.
Thank you, sir.
Your Honors, the first for interview this afternoon is Attorney Fernandez. And the first to interview the candidate will be the Honorable Judge Franklin J. De Monteverde. Judge De Monteverde, sir.
Thank you, Attorney Ed.
Thank you.
Good afternoon, Attorney Vicky Fernandez.
Good afternoon, sir.
Yeah. You are applying for 3 courts, no?
Yes, sir.
Okay.
It's your honor.
Now, you are being recommended by then Associate and now Chief Justice Jojado M. Peralta. Any relation to him, or how well do you know him? Or how well does he know you?
The the present Chief Justice was my former teacher in torts and damages when he was teaching way back in year 2000 at the UST College of Law. As
But you
to,
don't have any. You are not related to him.
no sir, I'm not.
Hmm. Oh, it's seldom and it's an honor to have been recommended by a chief justice.
Well, thank you.
Although he did it when he was still an associate justice.
Yes, I would like to let the Chief Justice know how much I appreciated his recommendation.
Okay. Now, Attorney Fernandez, I was going over your records and I was surprised to discover and to know that you are from Bacolod City.
Yes, sir, I am.
Have we met before?
Not to my belief, sir.
Not
In
to
fact,
your
it is,
belief.
yes, it is the first time I've actually seen you online.
Okay. Now, when did you pass the bar?
I passed the bar in 1988.
88. And after passing the bar, you practiced law in Bacolod or in Manila?
In Manila, sir. After I passed the bar, I worked at Sisip Salazar Law Office in Makati.
Uh-huh.
And from there on, I have started my law practice as a solo practitioner at Binondo area.
So when did you come home?
Well, I never
You never.
practiced at Bacolod, although I go there once in a while to handle family cases. But that's the extent of my practice at Bacolod.
So, but why did you run for a seat in the city council in 2010 when you are not frequenting Bacolod City? You are unknown here.
I know, sir. It was then that the incumbent mayor and the mayor who was seeking re-election both had cases filed against them at the office of the ombudsman. So I was thinking, why not give the people of Bacolod an option to select a fresh face? So that's why I ran, because I believe that I could possibly have helped in the
And
development.
under whose ticket did you run? Attorney, did you run?
Well, I run as an independent.
Oh, okay. Okay. The more reason that you didn't get elected. You didn't get.
Yes, sir. Yes, sir. I understand.
Yes, I was also going over your records and found out that you are you took your elementary and high school at Waming St. John's Institute, but you graduate high school in Iloilo.
Yes, sir.
And then in college, you took up accountancy at the University of Lasal dito, University of St.
Yes.
Lasal.
Yes, sir. Yes, sir.
But then after you passed the bar, you didn't desire to come back and practice here?
There were no greener pasture down at
Okay.
Bacolod.
What chapter of the IBP are you a member of? Yes, now.
Yes, I am a member of the IBP Chapter 2, Manila.
Manila. You have not been a member of the Negros Occidental chapter.
I know, sir.
Okay, that explains why. Aside from your other credentials, you took the bar, passed it, you were the 21st placer. Apart from that, you placed second at the CPA exam, accountancy exam, and then placed second also the customs broker licensure exam. Quite a record. But the most important thing here is that you took the number one, the mandatory requirement, which is the judicature program. At the time you took it, did you have any idea or did you have any interest of joining the judiciary?
Yes, I did, sir.
And had you applied for any of the positions before?
Yes, I had way back applied for the position of CA Justice, but the panel informed me then that my qualification is more suited to that of a justice at the Court of Tax Appeals.
Yeah, I think so also. Uh-huh.
Thank you, sir.
You would be more suited there. Now, going to your medical certificate, your X-ray result dated 15 July of 2020 contains this remark: pulmonary nodule right mid-outer lung. CT scan is suggested for further evaluation. What is this all about, attorney?
I had consulted with Dr. Joselito Chavez, and it was initially recommended that a biopsy be done to determine the cause. Because last year, my x-ray showed a clear lung.
Mm.
So, however, he also advised against it because of the COVID pandemic. He said that I might expose myself if I do a biopsy now. So what he did, he just recommended some medications, which I'm currently taking.
Okay. You have a legal and tax firm,
Yes, sir.
VCF Legal Accounting and Law Offices. How long have you practiced accounting?
Well, I practice accounting since I passed the CPA board exam in 1991.
So you passed the bar first before the accountancy?
No, sir. The bar was 2008. The accountancy was
Uh,
1991.
It's placed here 1988. It's 2008?
No, 1988 for the bar, sir.
Yeah, for the bar.
Yes, and my accountancy is 1992.
Okay. So for how long have you been practicing law?
Well, I have practiced.
Yung actual practice, actual practice attorney.
Yes, I opened my law firm in 1994. And except for that short stint at the Office of the Ombudsman, I have since been practicing uh, by myself.
Now you are presently teaching in a graduate school of law lessons about Anti-Graft and Corrupt Practices Act and Plunder Law, among others. Do you think the Sandigan Bayan needs to have a distinct or certain procedural reform that should focus solely in handling corruption cases aside from the present rules it has?
Yes, I think there are lots of cases being filed for under the anti-graft law. But due to the volume, these cases have dragged on for more than 10 years. Not only is it unfair to the accused, but likewise to the person handling it because the people at OSG, the Office of the Special Prosecutor at the Office of the Ombudsman, they often move around. So sometimes they just caught on with the case midway. So they're not familiar with what happened earlier. So I would hope that they could also apply the continuous trial and probably designate three divisions to handle exclusively these cases.
What can you say of this latest program of the president that he will run after the corrupt officials and
Well,
those in the government service? What can you say about it?
well, I think that is a very good move, and I think it brought the message home. Because in my dealings with public officials, they are less inclined to ask, unlike before, that they so emboldened to even ask you how much. Now, the public officials are more careful. They seldom ask, and they really do their job.
Sad to say, here in Bacolod, there are still government officers that have corrupt officers. Not only officers but employees. It's the corruption starts from the level below
Yes,
the
sir.
managerial level. So, personally, what could be the most effective means can you suggest on going after these corrupt people in the government service?
First of all, I would like the government to institute a no contact policy.
And
Like
how is that? No
like
contact policy.
okay, if the BIR would like to audit a taxpayer, all they do is write the taxpayer. They don't meet. They request the taxpayer to submit the documents, and we will evaluate it. In the same manner, for like let's say driver's license, the LTO could just send a notification to the driver. Okay, please send in your application and the fee, and we'll just mail it back. These are things that would limit the contact and hence bribery of public officials.
Okay, let's go back to the BIR, which you just mentioned. For the record, when the BIR intends to investigate the taxes paid by a certain taxpayer, what does it usually do?
Well, the first thing that it has to do is to send a letter of authority. This
Mhm.
is to initiate and to inform the taxpayer that you are now under tax audit. The ELA, the Electronic Letters of Authority, will specify the year and the type of tax that is being audited.
Is it only the letter of authority that is being sent by the BIR?
Well, that is the official. Uh, Sometimes the BIR will send you a letter notice.
Okay.
This is when when the computer department of the BIR noticed that when they compare data from third party, it does not coincide with the data submitted by the taxpayer. Hence, they send a letter notice asking the taxpayer, could you please explain the discrepancy?
What about this mission order? What is it about?
Mission orders these are special circumstances wherein the BIR suspect a
Mhm.
taxpayer to be evading the payment of taxes. So they will send field officer to survey, to watch, to interview in order to gather basic tax info.
Under what circumstance then can a tax assessment become final and executory?
It will become final and executory when the taxpayer doesn't do anything. From the final assessment notice or the final letter of demand. This is the trigger point. If you do not do anything within 30 days, you do not protest, then the assessment would become final and executory.
Okay. So what happened then?
Well, then the BIR has 5 years to collect on that assessment.
And how often can a taxpayer be investigated by the BIR?
Or once the BIR has forwarded a letter of authority to the taxpayer to audit a particular year, then that's it. The BIR cannot come in
Only
again.
once. Only once.
Only once, yes, sir.
Okay. What courts exercise jurisdiction over tax cases, attorney?
Okay. For the general rule is it is the Court of Tax Appeals. However, if the tax that is the basic tax that is being assessed is less than 1 million, then the jurisdiction would belong to the lower courts.
Lower courts. Okay.
Yes.
In excess of 1 million.
1 million and up, the exclusive original jurisdiction would be with the Court of Tax Appeals.
Okay. Now, what is a tax refund, attorney?
Tax refund is when a taxpayer paid in excess of the tax due. The taxpayer has 2 years within which to file a tax refund. administratively and judicially. Otherwise, the claim would be prescribed.
May taxes be the subject of an offset or compensation claims that individuals may have against the
No,
government?
no, sir. The rule is there's
Claim.
no.
Mm.
Yes, as a general rule, sir, you cannot offset
Mhm.
your tax due to what the government owes you, for the reason that taxes are the lifeblood of the government. They cannot wait. However, if the amount due from the government is already liquidated and has been appropriated, then in a ruling, the BIR said then you could offset them.
Okay. So it has its own exception also.
Yes, sir.
Okay. And what about these rulings or rules of the Commissioner of Internal Revenue? Have they an inherent retroactive application?
No, sir. All interpretations of the BIR pursuant to its authority to interpret tax laws are prospective in application.
Okay. Now, is this absolute?
Uh,
Are there exceptions to it?
well, in that war profit case, war profit tax case, the Supreme Court ruled that even if the tax law is applied retroactively, if it does
Mhm.
not prejudice the rights of the taxpayer, then it can be done. Because the court is so conscious that in the application of the tax laws, we do not unduly prejudice the rights of a taxpayer. So as long as that is protected, then the Supreme Court said it's good.
So you are familiar with the amendments to the new Code of Civil Procedure of 1997?
I had attended webinars, yes, sir.
Okay. Just a question. What are the modes of service under the amended Code of Civil Procedure?
Well, we have the same personal.
Uh-huh.
We have by mail.
Uh-huh.
In addition, the
What
Supreme
kind
Court,
of mail?
we have the registered mail,
Okay.
and even the courier services are now being recognized.
Okay.
And in places which do not have both, then we have the ordinary mail. The important change, I would say, is the electronic filing, which is now allowed.
Mhm. Aside from the electronic filing, ano pa?
For modes of service, sir,
There are
parang
6 of them.
all six of them. Uh, Substituted filing.
Hindi yan. Kasama
Wala
na yan
ba
sa
sa,
personal.
ano, I don't know, I need to be,
Fax. Facsimile.
okay,
Transmission.
the fax, yes, sir, the fax.
Oh,
But, okay. It
okay.
seems to be an old technology.
Okay. Have you heard of the Apostille Convention?
No, no, sir, what is that all about?
No? You better study. That's one of the modes of
Apostolate,
service. Apostille, not apostolate.
apostille. Sorry, sir.
Sige, anuin mo yan, ha?
Yes,
You
sir,
study that further.
yes, sir.
Now, you going over your records further, you are functioning along the superior range of cognitive efficiency. You are organized, meticulous, and prefers the type of work which challenges your ability to perform, but you have a critical attitude, immaturity, and inclination to stick to your usual ways. Do you think this do not hamper the way you interact with your peers, with your subordinates? This your kind of attitude?
It might, sir, if I remain to be stubborn, but I think I am flexible. I do
Stubborn,
listen.
not stubborn as a mule.
No, sir. I do
Uh-huh.
listen. I do listen to the opinions of other people.
Okay. So you are a leader by what?
By
What kind of
example,
leadership do you have?
by example, sir.
By example. And how sensitive are you to criticisms?
Oh, I don't mind criticisms.
Don't you get hurt by criticisms, especially when those criticisms tend to destroy you?
And no, sir, in fact, I sometimes ask my friends, can you please criticize what I did so I
Mhm.
will improve because I want to improve.
Okay. Now, at times, you also experience resentment and sadness. Is that correct?
There might have been times, yes, but
But you
that was,
don't get depressed.
oh no, sir, I have too much to look forward to.
Okay. So, my last question, Attorney Fernandez. You are applying for three courts. To your preference, what is the number one, number two, and number three, and explain.
My first preference would be the Court of Tax Appeals. I have devoted the last 4 years of my career to focusing on tax practice because I know the customs law, I know the tax law, and this should have been prepared me for my journey as an associate justice of the Court of the Tax Appeals. My second preference would be the Sandigan Bayan because I have worked at the Office of the Ombudsman. I have seen how cases are reviewed. I also work at the Office of the Commission on Audit for 6 years. I have audited the books of the government. I have been a team leader in our field audits. So all of this will contribute on how I would assess documents if and when I'm appointed as Associate Justice of the Sandigan Bayan. And my last but not the least preference would
Yeah.
be at the Court of Tax Appeals. Yes, sir.
Court of
Appeals,
Appeals.
sir. Yes, sir.
Okay. That's the last.
Yes, sir.
I would consider you for the Court of Tax Appeals.
Thank you, sir. Thank you very much for your
Okay.
support.
Anyway, that was my last question, Attorney Fernandez. And good luck. And I hope you make it.
Thank you,
Uh,
sir, very much.
okay. Stay safe.
Thank you. You too.
Thank you, Judge De Monteverde.
Yeah, Attorney Tali. Okay.
Thank you, Judge. The next interviewer is Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Tali. Good afternoon, Attorney Fernandez.
Thank you, and good afternoon, Your Honor.
Yeah, you are certainly an expert in tax laws, but there are only a few vacancies.
Thank you, sir.
In
I
the
look
Court of Tax
forward.
Appeals, there are more vacancies in the Court of Appeals.
Yes, I look
Uh,
forward to your support, sir.
if you are appointed as a justice of any of the courts, will you be closing shop the VCF accounting and law offices?
Actually, sir, I'm not that active anymore in my office. I have concentrated the last 4 years of my career in the academe and in
So,
writing books.
so will you be inhibiting in cases involving present and former clients?
Yes, sir, but I don't have that much of a client in tax.
All right. I'll ask you a question. This will be asked in the bar exams next year, if I am appointed as a bar examiner. The killing of a lawyer, is it an aggravating circumstance?
It would depend, sir,
Recently,
of the motive.
recently, recently there was a young lawyer who was killed the other day, and in the recent past, there were also lawyers who were victims of even unsolved killings. Should it be considered an aggravating circumstance?
Sir, it would depend on the purpose for killing the lawyer. If the purpose was because he acted in a case, then I would say it could be an aggravating circumstance. But otherwise, if there was really a purpose on his life, whether or not he's a lawyer, he's a doctor, he's a priest, then I don't think that should be considered.
But a lawyer is a officer of the court, isn't it?
Yes, sir,
And the court is part of government. Should that not be sufficient reason enough to consider the killing of a lawyer as aggravating by
uh,
the fact alone?
by that single fact alone, sir, I don't think so.
How do you explain the power of judicial review, Attorney Fernandez?
I think it's a very broad powers granted to the judiciary under the Constitution to review whether there was an abuse in discretion in any of the government offices or its officials. And I think so far the Supreme Court and the judiciary has stand up to its image to uphold this power.
If a law is against the provisions of the Constitution, can the Supreme Court or any court for that matter nullify the law passed by Congress and signed by the President?
Yes, sir, but there should be a petitioner. I don't believe the Supreme Court on its own could just say, okay, that RA XXX is unconstitutional. There has to be a petitioner who will file and challenge the constitutionality of the of the RA.
Is that not is that act of the court of the Supreme Court nullifying the act of Congress and signed by the President into law violative of the separation of powers?
No, sir. It is precisely because the Constitution wanted the people to feel that there's separation among the three departments of the government that it granted judicial power to the Supreme Court.
So you're saying that when the Supreme Court invalidates a law passed by Congress and signed by the President, the Supreme Court is asserting its supremacy and superiority over the two branches of government?
No, sir. It is exercising its duty to make sure that nobody abuse their powers.
Do you agree with the observation of former Supreme Court Justice Vicente Mendoza that the Supreme Court does not nullify acts of Congress? The Supreme Court merely declares the same to be unconstitutional, and therefore it is not the Supreme Court which nullifies the law, but rather the Constitution that declares that the law is invalid. Do you agree with that?
I agree in toto, sir, 100%.
All right. What is the difference, Attorney Fernandez, between public international law and private international law?
Mhm. I don't know. Public would be more on the municipal corporations. The private corporation would be more on the private corporation would be more regulated by the SEC. I'm
You,
sorry, sir.
you studied conflict of laws in law school. Conflict of laws pertains to what? Public international law or private international law?
Public, sir.
public.
I have to apologize. This has been what, 20 years ago?
All right. Who can you make an educated guess? Who is the father of the modern doctrine of international law? I'll give you a hint. It is not Christopher Columbus or Ferdinand Magellan, but who is the father of the modern doctrine of international law? You should know that.
I'm sorry, sir. I can't. I can't guess.
You cannot guess. All right, let's talk about something close to your heart. Oh, before that, the Land Transportation Franchising and Regulatory Board (LTFRB) issued a memorandum circular 2020-076, which will take effect next week, December 1. The LTFRB requires that all applicants for public utility vehicles should plant one tree for every unit being registered. The circular covers all applicants for the issuance of a new certificate of public convenience with at least 10 units, as well as all corporations and cooperatives applying for the extension of their existing franchise. There are no right or wrong questions, but in your opinion, is this circular valid and constitutional?
Yes, I did read about that article on the planting of trees. It is a good endeavor, and to require those applicants to plant is a nice way of requiring them to contribute to the environment. Now, it would actually depend because the franchise is a privilege. So I do not know the extent of the powers of the LTFRB, but the LTFRB could always state that to support the general principle of and probably as an answer to the environmental problems that we have.
But do you think it's valid? It's constitutional? You explained that the objective is noble, but it does not necessarily mean that everything noble and commendable is valid and constitutional.
But I would first look into the powers of the LTFRB if it has been granted a wide discretion in the grant of the privilege, and it could justify the planting of trees as one of the requirements, then why not?
Is evidence not presented, not presented in the administrative claim for refund in the Bureau of Internal Revenue still admissible? Can it still be presented before the Court of Tax Appeals?
Yes, sir, it could.
What is your basis?
Because the CTA is they tried cases de novo, even if the document has not been presented before the BIR for claims on administrative refund. Thus, the CTA ruled that it could still accept these documents.
Is that not tantamount to a waiver of evidence since you did not file it before the BIR?
No, sir. There was this case, and the contention of the BIR is no, that taxpayer did not file a particular document, and so it denied the application for refund of the taxpayer, and so the taxpayer filed a petition for review before the CTA. The CTA ruled that it does not inhibit or prevent them from requiring the submission of that particular document when the submission of the document would help them in administering justice.
Are submarines subject to real property tax?
uh, if they are attached,
And they
because,
they're
because
floating. They're floating.
but if they are, although they
Suppose
are,
a company owns a submarine, is it subject to real property tax?
there was this case wherein a barge, although floating, but it was ruled that because of the permanency of the structure was just floating there, and
How can it be permanent? It is no longer a submarine. So I think it was declared to be a machineries.
machineries and equipment.
Is there a difference, Attorney Fernandez, between a real party in interest and a party with legal standing? Or you can give an example. A real party in interest and a party with legal standing.
Okay. Real party in interest is the person who is directly affected. While a person with legal standing, although it does not affect them directly, they have as locus standi to file the case, such as a taxpayer. The taxpayer could always file a suit and question
In all
the
cases, in all
no, no,
cases,
when the revenue, when taxes are being used for an illegal purpose, then it is said that a taxpayer can file a suit in court questioning the expenditures.
what are the remedies available in case of errors in the exercise of jurisdiction?
Okay. I would think that they have to file a petition for certiorari under Rule 65 if they acted beyond their jurisdiction. And this could be filed in any courts, not only at the Supreme Court.
May a writ of habeas corpus be availed of in cases of detention by virtue of a judicial process or valid judgment?
Uh, my answer is no, because there is an order to detain issued by the judge.
Are there exceptions? Can you think of exceptions? That's a general rule.
Yes,
You cannot avail of a writ of habeas corpus if the detention is by virtue of a judicial process or a valid judgment. Are there exceptions? Can you think of exceptions?
well, the lawyer could always go to to the judge who issued that order and file for a motion for recon. There's another writ, the writ of amparo.
Oh no, we're talking of we're talking of
I'm just
we're talking of habeas corpus.
habeas corpus only. Well, habeas corpus has its limit. It just say produce the body.
Think of an example, an exception wherein although the judgment is valid and the person is detained, you can avail of habeas corpus.
Sorry, sir, I cannot.
Supposing the person is convicted and the penalty imposed is excessive, do you think the person convicted can avail of the writ of habeas corpus?
There are other judicial remedies, sir. They should have filed a motion for recon when the judge issued that order.
Precisely. Supposing the MR is denied, can the person convicted, but because of excessive penalty, avail of a writ of habeas corpus?
No, no, sir. They should have availed of Rule 65, questioning.
Not the writ of habeas corpus.
No, sir, because he was detained legally. I think the purpose of the habeas corpus is you have to free the person. But since there is a valid order of conviction, I don't think you could do that.
All right. My last question is, Supposing an accused in a criminal case is erroneously acquitted, what is the remedy of the complainant? Taking into account the rule on double jeopardy,
Jeopardy.
what is the remedy of the? That's my last question.
I don't think they have any remedy except when they allege extrinsic fraud, maybe.
So you cannot avail of certiorari.
No, sir, because there's double jeopardy already. He was
There
acquitted.
no avenue to establish grave abuse of discretion.
Probably,
The premise is erroneously acquitted.
yes, sir, but if the Supreme Court ruled there was grave abuse of discretion, do you think that the
You're now the
that
one asking
first?
the question.
No, sir, I'm asking myself. So
You're asking yourself.
yeah, if the Supreme Court grants your petition for certiorari, you
Okay, okay. One final question. I had to ask you this question. This is the same question asked of me when I appeared before the Judicial and Bar Council several years ago. I was not able to answer the question. That's why Justice Gutierrez did not vote for me. And I only got the minimum number of 4 votes.
oh,
Fortunately, the president is sympathetic to those who have lower votes, and he appointed me. So, what is the doctrine of operative facts? My final question.
does this mean, sir, you will not vote yes
I
for
was
me?
trying to assuage you that even if you're not able to answer it,
Okay, I will be like you, sir. I will not be
did you
able to.
guess what is the doctrine of operative facts?
Yeah, a little hint, sir.
All right, you just research on that. Thank you
I,
very
I
much, Attorney Vicky Fernandez, and good luck.
thank you, sir, for your time. Thank you.
Thank you, Justice Tiham. The next interviewer is Honorable Judge Toribio E. Ilao Jr.
Yes,
Judge.
thank you. Thank you, Attorney Sally. Just like Attorney Aricheta emphasizing my name as Toribio.
Ay,
Very rare, Santulo Toribio. Anyway, thank you, Attorney Sally. Yes, good afternoon. How do I address you? Can I just
Vicky.
address you, Vicky? Because
Yes, sir.
you're a doctor.
Thank you,
Very
sir.
rare, but doctor in DCL, doctor in civil law, because we had a professor then who obtained also a degree of DCL from UST. I remember that's Dr. Veneracion from Bulacan. And we had also I encountered a practitioner, Dr. de la Madrid. Any doctor also, a politician, Formula Joey Salonga was also a doctor. What is your story, doctor?
Story of my life.
A single but with 13-year-old child by the name of Dax Fernandez Sudario.
That is one of the fallback of being a practitioner. So way back when I started my law practice, I handled a action to annul marriage on behalf of my friend. And it was so ugly in that both tell stories about one another. And during that time, I think it was not yet, it was open to the public during my time. It was in the 1990s. And I told my partner of 25 years, what's the sense of having a paper if you don't get along with your husband or your wife? And then when you want to separate, you have to go into this accusation. So my partner, also a single man, we have been together for 25 years. He agreed, okay, why not? Let's just live together as husband and wife. And we had, and our families and our friends had recognized that we are both common law husband and wife. And it seems to me that it worked because knowing that you don't have any paper to hold the guy, you make sure you do your part. You make the marriage fresh, a place where he looks forward to going home at night.
He's still around.
Yes, sir, he is.
Anyway, you're very frank and honest. I really admire you.
Thank you, sir.
So for the record, your records that you are a legal and tax practitioner for a total of 24 years, prosecution officer 2 at ombudsman for 1 year, and in the private sector for more than 3 years. Also state auditor at court. This is a commission point
Audit, sir.
audit for more than 3 years.
6 years, sir.
Yes, I will not ask you about your practice and accomplishments because obviously it's been there. It is on the records that you may be worthy of a seat in the appellate court.
Thank you, sir.
But could you convince us to nominate you over other judges applicants and therefore disregard careerism in the judiciary? Because the Judicial and Bar Council encourages members of the judiciary for promotion.
Yes, sir. Yes, it's one of the things that judges should look forward to, having served in the judiciary, that you have to be given also priority. However, sometimes there is also a need to bring in people from the outside. The mentality of judges could, for like practicing inside the courtroom for 10 to 20 years, could affect their fresh outlook. They don't have the insight of taxpayers or the people in general. So it is always good to bring in somebody from the outsider who could help in the, if needed, in the reforms in the judicial uh, office. On top of that, for the last 4 years, I have devoted myself to perfecting my knowledge in tax law. In fact, when I started practicing and I was a professor at the FEU, I told my class to go to the Court of Tax Appeals to research on tax matters. But it turned out that the library of the CTA is not filled with such plentiful a book in taxation law. So that's one thing that I would like probably the CTA to put a reform upon. And also another outlook that I don't think judges might have is the public should be made aware and they should be allowed to watch the court in action. I noticed the zealousness of the guards is that if you want to watch or observe, they have to ask you a lot of questions. And I feel that, I wanted to bring my class, the Court of Tax Appeal, to observe, but I cannot. So, beside my qualification, there is also the passion. I think that is more important. You have that passion to serve. You want to go there and to do something more for the taxpayer or even for the government. So that is my view on the matter, sir.
All right, for long years in private practice, what can you bring to the judiciary from your private practice? What principles have you consistently lived by?
Okay, the first one is the Section 1 of Article 3 of our Constitution, that no person shall be deprived of life, liberty, or property. That is, I think, the most important thing. because in most instances, the party or the taxpayers did not have their day in court because of technicalities. But I'm glad to know that these days, the judiciary is more open and are not so strict about technical rules. So that's one observation I had.
And how have you embodied the principle of integrity in your entire legal career?
Yes, sir. If even the guards in our office would know how strict I am. Well, they know from the way I act that I'm not somebody to be approached about bribery because in the first place I will immediately tell them that please don't do that. It is against my principle to be doing that. So I always stand by integrity. That is why I joined the office of the ombudsman. Otherwise, I would not have joined it.
Let's go to your PDS, more particularly with your SAL end. In 2019, you declared gross revenues of 318,610. In 2018, 180,000. In 2017, 296 for 640,000. How were you able to obtain a net worth of 56 million over the years, considering the trend in your gross revenues?
Yes, sir. Yes, even when I joined the office of the ombudsman, I had already a net worth of more than 30 million. The best years of my practice was when I started my law office in Binondo. I have lots of clients. It's only in the last decade that I have tampered down on accepting cases. That is why my earnings are limited to my income from the books and my professorial earnings. Uh, you could say that it all ends up because I have good investment sense. In that when I earned something when I was in my 30s, after appropriating enough for the office, I would immediately convert my peso to dollars. I remember way back then, the dollars were just like 29, 30 to a peso. So that is the way I am. I'm quite thrifty. That's why I end up with so much. And also because when I started my practice, I told myself that when I reach the age of 40, I will retire. So I work even up to the wee hours of the morning, sometimes sleeping at the office until 4 o'clock because I was a solo practitioner. So I tried to do everything and I told myself, just do it because you're young. Your body could still take it. So I accumulated much during my middle years when I was in 30s. But when I reached my 40s, I trimmed down my practice and even when I was in 50s. Now I'm only concentrating on my academe.
Alright, you're applying for the vacant positions in three collegiate courts, Court of Appeals, Court of Tax Appeals, and Sandigan Bayan.
No volume?
All right,
Yes, sir.
Doctor,
Yes, sir.
do you hear me? You're applying for the three vacant positions.
Yes, sir. That's right.
And I repeat, it may be dangerous because of just like saying all or nothing in the end.
What is dangerous, sir?
All or nothing. All the vacant positions in the collegiate courts. At any rate, what are your expectations in the appellate courts?
Well, I expect to do as well as the other justices. Like I noticed that at the CTA, the justices are really good. I read their decisions. They were penned very well. I hope that when I reach that position, I would be mentored by them to do the same. I will, of course, observe the protocols. And if there are needed reforms, I would not hesitate to discuss it with the presiding justice. But always, I will stick with what the law provides.
And what do you think is the most important quality that an associate justice of the Sandigan Bayan, associate justice of the Court of Appeals, or the Court of Tax Appeals must possess?
I think, sir, it's integrity. Competence you could earn, but integrity, the character of a person is hard to change. That's why it's important that a candidate should have integrity.
Do you possess that? Obviously.
Yes, I believe,
Yes.
sir, I do. I do.
You believe. But convince this council that we going to believe you and you're embodied with such integrity.
I am, sir. You could do field investigation about my character. I have never bribed anybody. If my client wanted to bribe anybody, I told them, you do it by yourself. Do not tell me about it. I do not want to be an accomplice to your crimes.
What is this case about? Reckless imprudence resulting in damage to property, filed by a certain Carol F. Reyes. It was in the August 2000. What is
Yes,
this all about?
yes. This was along Quezon City Hall. I was in a hurry to attend a hearing. And this lady was just driving so slow, and he braked immediately. So I bumped the rear of of her bumper. There was very slight damage. But he just came from abroad. He was a flight stewardess. So I asked him, how long have you been driving here in Manila? You cannot just say you're gonna stop in the middle of nowhere because in front, there's no car in front. And I never expected her to stop. Maybe my mistake. So it was settled.
Alright, can you discuss your platform for each of the appellate courts you're applying for? What novel reforms are you going to introduce to better serve the public and the administration of justice? Let's start with the Court of Appeal.
Yes, foremost, I would like to say that the present presiding judge and the justices have done well. And I do not have much, except that I would like them to consider continuous trial. Because this would help not only the taxpayers for Court of Tax Appeals, but also for the judiciary to finish one case. Sometimes when we handle so many cases in one day, we tend to forget what the witnesses say. Although we do take notes, but I believe it would be better if we have a continuous trial, say a week, and then move on to the next. So that is also my reform for the Sandigan Bayan, in the sense that I know somebody who has been accused at the Sandigan Bayan. It has been pending for the last 20 years. And the guy doesn't have work and he has family and he just cannot move on with his life. So I would feel that if the Sandigan Bayan could please consider the continuous trial for cases involving probably 5 million below. For the Court of Appeals, uh, they're doing well, so I don't they're mostly table decisions. So there's not much I could say about the Court of Appeals.
All right, let's go to your judicial philosophy. All right, Doctor, do you subscribe to the view of some juries that the Constitution is a living document whose provisions must be interpreted in light of the current socio-cultural and economic context?
Yes, sir. I believe in it because even the magistrates should consider what is happening outside. We cannot just stick with what the book or the provision states. It could be interpreted considering the circumstance. I would like to think that Congress, when they pass the law, are all more open-minded in the sense that they consider that the future might be different, but the principles are there. So it's one of the factors that ought to be considered.
How do you view the doctrine of stare decisis?
It is good in the sense that it gives finality to events so that the parties could move on. That is what is important because if the case or issue has not been settled, the parties keeps on hoping, oh, I might win, I might lose. But once the judgment is in and it's final, then the parties has no other options but to move on with this life.
All right, do you agree with this statement? And I quote, the court, as the highest court of the land, may be guided, but is not controlled by president.
Yes, sir. Yes, sir. The Supreme Court should be made to do what it thinks it should do. Nobody can order it to do or act or decide in a particular way because we appointed them as justices of the Supreme Court. We have to believe that they have integrity and the knowledge and the competence to act on cases or petitions filed before them. And we don't have the right to tell them to do this and to do that.
So you would rather disregard president?
Not, no, sir. But if there is justifiable cause to change the stand of the Supreme Court, why not?
Is this a question of creativity, VP, doctor?
Sir, sir, I would say it's more of justice, fairness, and equity. If you feel that that party is, it's, the decision is unfair or inequitable, the Supreme Court could always come in and decide in a way that it renders justice to that party.
All right. Are you a computer literate or computer proficient?
Yes, sir. I type very fast.
And how do you keep yourself abreast with recent legal developments or court
Oh,
decisions?
I often read the websites of the Supreme Court, the CA, the CTA, and the BIR, of course.
Do you avail of the online resources in your legal research?
No, sir, but the Supreme Court does have an e-library, which is provided free of charge.
Hmm.
You could
What are the challenges? Yes, please. Sorry.
no, I could always research on decisions through that e-library of the Supreme Court.
All right. What are the challenges in automating court processes, and how will the court ensure the automation programs of the judiciary will be effective considering possible glitches or roadblocks?
Well, I am one in supporting that electronic effort because in my practice, like decisions rendered or any court processes that is set by a court in the Visayas would often reach me like 3 weeks after. And it would set a date of hearing, like let's say January 3, and I received the notice January 10. So that electronic change is a very big factor. And so far, the request for to acknowledge any emails received is a good document. For glitches, I cannot say because I'm not a computer expert on how to prevent it. But I think the Supreme Court is in the right direction.
All right, let's go to psychological question or critical or question. Would you rather lose all of your old memories or never be able to make new ones, doctor?
I would rather retain my old memories.
Why?
Well, these are the years where I grew up, and I'm very fond of my mother, and I do not want to forget her. So that's it.
Sorry, I'm going emotional, doctor.
I'm sorry. I'm sorry. I'm sorry, Justice. I'm sorry.
And what do you wish someone would ask you?
About anything?
Anything.
Oh, well, I hope that person will help me teach him or her how to be financially independent.
What do you actually mean by that?
Well, I would teach him or her how to invest his or her money rather than leaving it in the bank.
All right, my last question, doctor. Could you describe the process and benefits of wearing a seatbelt?
The process is simple, but the benefits are great. It would protect the life of the driver as well as, if I'm the passenger, also my life. It has been shown to be very effective, and I would think that everybody should obey it, not only because it's a law, but because it's for your own good.
Right, thank you. That was my last and final question, the doctor.
Thank you,
Thank
sir.
you for your time.
Thank you, sir, for your
It's
time.
very interesting. And good luck. I hope you're going to make it.
Thank you, sir, very much.
Thank you again.
Thank you, Judge Ilaw. The next interviewer is Honorable Justice Jose Catral Mendoza.
Ayan. Okay na? Can you hear me?
Yes, Justice.
Oh. Hello.
Afternoon, Justice.
Good afternoon, Attorney Fernandez.
Yes, sir.
When did you take the bar?
I took it in 1987 and I passed it in 1988.
87. So I presume you know the case of Galman versus Sandigan Bayan.
Yes, sir.
What was
A
the ruling then?
controversial.
Yeah, what was the ruling then?
Oh, sir. I have gone shy away from practice of criminal cases. I'm so sorry, sir.
Oh, criminal cases. No, this is special civil action, certiorari.
Oh,
One of the issues there was certiorari. Justice Tiham was leading you to it.
ah, oh,
What?
Doctrine of operative fact.
No, no.
What was the other one? No, that's all I have.
Erroneous decision.
Oh, yeah, erroneous decision.
Is there
Yes.
no remedy anymore?
I think
You will stick to it?
the Rule 65, sir.
Yes. Your answer earlier that there is no remedy because of double jeopardy.
Oh, yes, sir. Otherwise, it's better to.
I'm not asking if it's better or what. What is the remedy?
I would think
Is that a remedy? Is that a remedy?
I would think, sir, one of the remedies that could be used would be extrinsic fraud.
Extrinsic fraud.
Yes, like
You also mentioned that earlier.
yes, the
Extrinsic fraud. How about grave abuse of discretion?
yes, sir. But to my mind, okay, supposing the Supreme Court will grant
Hmm.
the petition, what would happen then? Will you ask the acquitted accused to come back and continue the hearing? I
But
cannot. Yes, sir.
you cannot imagine. You
Cannot
cannot
imagine it, sir.
imagine. But did you read the case of
I
Galvez
did way
versus?
back, sir. The way back 20 years ago.
What was the ruling of the Supreme Court? Even if you do
Can't
disagree
remember
with it.
much. Can't remember much about it, sir. It has been a while.
Oh. Okay. Review that case.
I will, sir. I will, sir. I noted it
Because
already.
there will be cases brought before you. You are fond of mentioning extrinsic fraud. Where is that ground? What is the remedy where that ground is usually invoked?
Well, one of the ground would be to annul the judgment.
Yes.
Uh,
That is the remedy.
yes, an action to annul the judgment.
What
For
else?
reason of extrinsic fraud. Well, that is usually my remedy.
Yes. Oh.
So
Where do you invoke it? Extrinsic fraud.
when there are no other remedies, then I invoke it.
When there are no other remedies, you invoke it.
Yes, if I want to overturn the decision
Of a final and executory judgment, you use that.
yes, sir. Well, you could also use it in interlocutory orders.
I see. Oh. You're applying in the Court of Appeals. What are the three general categories wherein the court can receive evidence? General categories, not specific
Uh,
instances.
this is a guess, but
Have you not read? Did you read the internal rules of the Court of Appeals? You said you prepared. You have been updating yourself.
yes, with their cases, sir.
Yes.
With their cases,
Good.
for the CTA and the
There are
Sandigan Bayan, I did the
yes
internal rules.
in the Court of Appeals.
I did that, sir. They have 69 justices.
Oh, but I'm not asking the number of justices. I'm asking the three instances where the Court of Appeals allow where the Court of Appeal allows reception of evidence. Three general categories.
In the best interest of justice.
That's very general. That's a mother statement.
Yeah, that's what we use, sir, when we file cases.
That's
And
what
there's
we
no
use.
other ground.
No other ground.
In the interest of justice, equity, and fairness.
It's always that. Always that.
Yes. I am so
You are
sorry.
in the you are in the Court of Appeals. If a party invokes those grounds, you will allow a hearing for the reception of evidence.
Sure, but it should be supported by evidence.
Mm.
You
So
cannot just...
you do not know the three categories.
I would like to think that the CA would allow this for fairness.
There are three categories. No, you have not come across it.
Oh, I
The
might
three
have. What
No.
are these, sir? What are these?
I'll give you one. New trial.
Okay. New trial. Requesting for new trial. New evidence.
What else?
For new evidence?
What do you call that? Newly discovered evidence.
Yes.
What do you call that rule?
The rule? The newly
Yes.
discovered evidence?
Yes. What is that? Okay, I will ask you directly. What is the Berry rule? Berry rule.
Oh, I am sorry, sir. I have not been in practice for the last 4 years.
I see.
Yeah, I've been focusing on my academe.
Berry rule is the rule on newly discovered evidence.
Okay, sir.
Okay.
I will research on it after the interview.
And also Galma versus Sandiga Bayan.
I will refresh on it.
Yes. Now, can you what is the rule on annulment of judgment?
Like when you could file it?
No, not the period. Just the rule, the general rule. You are applying in the Court of Appeals, right?
Yes, you could have it annulled if there's no grounds.
There are no grounds. There are no grounds
to support the factual, or it's against the rule of law.
If
it's not supported by the law or the rules.
You file a petition for annulment, not appeal.
Yes, appeal, sir. You appeal when...
What is the... Okay, I'll be direct. What is Rule 47 in the rules of court?
You got me there, sir. You got me there.
I will help you. That is the rule on annulment of judgment.
Yes.
What are the grounds allowed under Rule 47? You're applying in the Court of Appeal.
Yes, sir. I know. I apologize.
Because I thought you know it, because you always mention extrinsic fraud. One ground is extrinsic fraud. What is the other ground?
To annul marriage, to annul judgment.
Yes.
No jurisdiction, sir. The court does not have any jurisdiction.
Two. Okay.
Okay.
You are also applying in the Court of Tax Appeals. You have read the revised rules of the Court of Tax Appeals?
Yes, sir.
You teach that on. Section 2 of Rule 1 states that the rule shall be liberally construed in order to promote their objective of securing a just, speedy, and expensive determination of reaction. And Section 3 states that the rules of court in the Philippines shall apply suppletorily to these rules. Okay?
Yes, sir.
Okay. If a decision of the CTA or an RTC decision on in a tax case, you want to question, it has become final and executory. Can you file an action for annulment with the CTA?
The jurisdiction of the CTA provides that in all cases of decision from the RTC, either in its original or affiliate jurisdiction,
Appellate jurisdiction.
can be appealed to the Court of Tax Appeals. Now, it could be said that considering that this is a tax case, it would also involve the annulment of that decision, of that tax decision. And therefore, the CTA
No, my
would have jurisdiction.
my question earlier was, the decision has already become final and executory.
Oh.
So if it's final and executory, can you avail of annulment of judgment under Rule 47? Because in the Court of Appeals, you can avail of that rule. Now, under Rule 1, Section 3, the rules of court in the Philippines shall apply suppletorily to these rules. Correct?
Yes, sir.
Oh, can a taxpayer, can a party file a petition for annulment of judgment before the CTA?
Yes, sir. Following your reasoning.
My reasoning. Following my reasoning. What was my reasoning?
That the rules should apply suppletorily. Then I would say that considering it is also a tax case, then the CTA would have jurisdiction. But I have yet to read. A case on annulment of judgment that was rendered by the CTA.
Wow. How about the Supreme Court?
Yes, sir.
Supreme Court decision in a tax case.
Yes, sir. The Supreme Court being the highest court of the land, they have.
No.
What, sir?
Do you remember any ruling? Because you're always reading Supreme Court cases. What was the ruling of the Supreme Court? Can one avail of a petition for annulment of judgment in the CTA?
Yes, I would believe so. Because you said the rule is suppletory, should be applied suppletorily to the Court of Tax Appeals. But in the same manner that it can be filed before the CA or the Supreme Court, I think in tax cases, the original jurisdiction should belong to the CTA in tax cases.
Oh, you read the rules creating the Court of Tax Appeals, right?
Yes, sir.
And also its amendment.
Yes, sir.
Was the CTA given original jurisdiction on a petitions for annulment of judgment?
No, sir, but you did mention that it should apply suppletorily.
So you are not aware of the Supreme Court decision?
The Supreme Court, yes, they could annul judgment.
No. We are talking about the power of the CTA.
CTA, no.
Yes.
Okay. Yes, it's not in the rules, sir, that the CTA has jurisdiction over a petition to annul
even if you mention
judgment.
suppletorily.
No, sir. I then
You're changing your answer?
No, sir, I don't think so. It was the intent of Congress to grant the CTA the original jurisdiction over tax cases, then I would think that they should be given that power.
But was the CTA given that power?
Explicitly, sir, no.
No. So can a litigant file a petition before the of annulment of judgment before the CTA?
I would think so, sir. Like, if there's a judgment by the CBAA
Hmm.
and no appeal was filed on time,
Becomes
and
final, di ba?
it
It
becomes
becomes final.
yes.
Oo.
A party litigant could file probably a judgment, a petition to another judgment of the CBAA.
Invoking lack of jurisdiction or
Yes, sir.
extrinsic fraud.
Yes, sir.
Okay. There is already a Supreme Court decision here in the Ilihan case.
Ilihan.
Yes. Oh, yeah. You review on that, so you
Yes,
can
sir.
lecture on it.
Yes, sir. Thank you for the tip, sir.
So you can lecture on it. Oh, you have been mentioning extrinsic fraud. What is intrinsic fraud? You
Uh,
have not been using it, so you have been using extrinsic fraud. Now, what is intrinsic fraud?
these are frauds that was committed on the parties outside.
Outside,
Yes, outside. Like,
outside.
yes,
That's why you call it extrinsic.
yes,
Ah,
sir. Yes, sir.
you call it extrinsic. I'm asking, what is intrinsic?
Oh, I'm sorry, sir. I didn't.
Yes.
Intrinsic is this happens like
It
the
happens
the
during the
witness.
trial.
Yes, during the trial. It happens
Yes.
during the trial.
Yes.
When, like,
Oh,
the
the witness was
judge.
prevented
Yes, yes.
from testifying. That
Yes,
is
sir.
intrinsic.
Yes, if that testimony of the witness is quite relevant,
Oh,
but the council should have made notice that this person would have attest to so and so. It's
so
more
you call that intrinsic,
the no,
extrinsic. Yeah.
no, no,
During
no,
the
no, no, no.
trial, he was prevented from adducing evidence. That is
Uh,
during the trial. He was
yes,
prevented from adducing evidence. He
uh,
committed fraud.
yes, sir.
That,
Intrinsic
that
fraud.
is that intrinsic fraud?
Usually this happens in a court proceedings.
Yes. Oh.
Oo. That's why
What's
you
that?
call
What
it
is that?
intrinsic.
How do you distinguish one from the other?
Well, the other one happens outside, meaning
Outside.
okay. There's a witness, and I told the witness that, hey, there's no hearing. It has been canceled. It has been reset.
Hmm.
So,
You you
so
have
this,
availed of that ground, di ba? You
oo.
mentioned earlier you usually use that ground. Have you used that ground?
No,
That
sir.
reason?
No, sir. No,
Or what
sir.
extrinsic fraud did you use?
Like what I said, the other party informed. Like, let's say ako, they inform us, hindi, walang hearing, wala si judge. And then, there was a reception of evidence. So I could argue that, hey, had I been there, I would have objected to the testimony of this witness for being hearsay.
There was fraud?
Well, I would say it is extrinsic fraud because
Yes. Now, I'm asking, what is intrinsic fraud?
intrinsic
In,
fraud, um, like they submitted a forged document and it was admitted. I would think that is an intrinsic fraud.
the fraud that it was the issue, it was the issue, it was the very issue in the case, right?
Yes, sir.
Do not agree with me, baka mali ako.
Tama ka, sir.
Tama. Oo. What is the subjudice
Sub judice,
rule?
that it has already been ruled upon.
Are you sure?
Or sub judice. Yeah, it's part of another case.
Oh, okay. You research on that subjudice rule. Oh. What is the constitutional provision on freedom of expression, if you remember?
It shall be, the expression or communication shall be inviolable. It should not be violated, or the freedom should be upheld.
Hmm.
The freedom of religion.
No law shall be passed abridging.
Using the freedom of
Yeah,
religion.
you now remember religion. Why did you go to religion?
Oh, I'm sorry. I'm sorry. I'm sorry, sir.
Oh,
Okay.
maybe you're tired already. Oh, what are the elements of the freedom of expression?
Well, there should be good faith. That's number one.
Hmm.
You're not
Yeah,
motivated by, you're not motivated by an ill will towards a person,
the elements, the requirements,
sir.
the essence of a the freedom of
Oh, the
expression.
essence.
Yes,
The essence is all people should be free to express themselves, their views, and nobody should hinder them from doing so, as long as it is not tantamount to rebellion or.
there are two general categories. I'll give you one: freedom from prior restraint. Do you remember that? Freedom from prior restraint. Do you
Restraint.
remember that?
That you cannot restrict a person.
Continue.
Yes, sir. You're asking me for the second one?
Yes. No, okay.
Prior
That
restraint.
one is prior restraint. What is the other element or the essence of freedom of expression?
Um, must be
No.
tired, sir. My mind is no
Uh,
longer working.
freedom from subsequent punishment.
If you do it,
Remember? Oh,
freedom from,
you're from Bacolod.
yes, sir, freedom from
Oh,
certain
very good. Oh,
punishment.
so I'll ask you about Diocese of Bacolod versus the Comelec. Oh,
The diocese.
of the
Yes.
Bacolod. Oh, what are the general limitations of the freedom of speech? It
Yes,
is in Diocese of Bacolod versus Comelec.
yes, I remember that case, but
Yeah. Yes.
it
No,
was against one of the candidates. I think wearing of black uniform, sir. I cannot remember.
you forgot Team Buhay, Team Patay.
Yeah, the wearing of the, is that black? The black.
Billboard. That what I the it was about the billboard put up by the church.
Uh huh.
Uh,
Uh huh.
saying this is the Team Buhay, this is the Team
Team
Patay
Patay.
regarding
Ah,
because of their adherence to the or opposition
yes,
to
sir.
the RH law.
Yes, yes. I
So
remember that.
in that case, there are two general limitations or restraints of the freedom of speech. What are those?
Okay. That this is a choice. That the people should have the freedom to select.
Uh, the two general categories of content-based restraint and content-neutral government regulation. Okay, you read again that case of Diocese of Bacolod versus Comelec. Oh, can you still or tired na?
Yes, sir. A bit
Very
tired.
tired, you're very
Very
tired.
tired.
Oh, pinahirapan ka ng tatlo. Hindi naman kita pinahirapan. Oh, cumulative. Oh, sige, that will be all.
Thank you, sir,
Oo.
very much for understanding.
Kasi I see that you're very tired na. Oo.
Thank you, sir, very
Oh,
much.
sige. You're already excused. Oo.
Thank
Thank
you,
you.
sir. Thank you, sir.
Thank you, Justice Mendoza. Thank you, Your Honors. The next candidate to be interviewed is Judge Caridad V. Galvez, presiding judge of the Regional Trial Court, Branch 43, Dagupan City, Pangasinan. She is an applicant for the Court of Appeals. First to interview Judge Galvez is Honorable Judge Franklin J. de Monteverde.
Thank you, Attorney Tali. Good afternoon, Judge Galvez.
Judge Galvez.
Okay, go.
Sorry, sir.
Lakasan mo.
Good afternoon, Judge Galvez.
Good afternoon, sir.
Yeah, I've known you for quite some time. How are things in Dagupan?
Fine, sir. Okay lang.
Okay lang.
Po.
You've grown a little thinner.
Because of the work, sir.
Okay naman. So, for how many years have you been in Dagupan?
Nagupan, sir, 11 years as an RTC judge. But prior to that, I was a prosecutor there also for almost 5 years.
Okay. And what is your caseload now?
I have 500 plus, sir.
500 plus. Now, prior to your appointment as in the judiciary or to the judiciary, you were a prosecutor, and were you able to practice law before you're
Yes.
being appointed to the prosecution service?
Prior to when I passed the bar, I practiced for a while, and then I got employed in a bank in Manila. I worked in the legal department of equitable banking for almost 5 years, and then after that, I went back to the province and then ran as municipal councilor. So I served for 6 years, sir, and then after that, I applied for. I applied at the prosecution service.
For how long have you been in the practice of law?
For
All told.
all throughout,
Yeah, all
including
throughout.
almost 35 years because
35 years?
yes,
That
because I
long?
passed the bar 1984. Yes, I passed the bar 1985, sir.
85. I noticed that you were active in politics before. And as a matter of fact, you were elected as a councilor in your municipality.
Yes, sir. I was elected twice as municipal councilor.
Okay. And considering your stint there as a councilor, why didn't you run for the vice mayorship or mayorship for that matter?
I actually ran for vice mayorship. However, I lost, sir. That's why I got discouraged. And that prompted me to apply as prosecutor.
Okay, where did you finish your College of Law?
In University of the East, sir.
What year?
1980 to 1984.
Your record shows that you have a Master of Laws degree. You finished?
I am not. I'm not done yet, sir. I am actually enrolled right now. I finished 24 units already, and I'm still enrolled now.
Okay. How long? For how long will you still be taking up this master's degree?
I believe probably one sem more, and I'll be done.
Now, going to your medical certificate, while you were certified to be medically and physically fit, yet your record shows that you're high on lymphocyte, monocyte, basophil, and then your total cholesterol borderline high. Kindly explain, or if you are taking medications for this condition.
No, I'm not taking any medication, sir. I referred that to my doctor, and according to the doctor, it's part of, advancement of age, growing old. But I just have to limit my food intake. But I'm feeling okay. I'm all right. It
How about
doesn't
this?
for my job.
How about this finding on your chest X-ray? You have a tortuous aorta. What is this?
Yes, actually, first when I received the result, I got worried too. But then, after talking to my doctor, according to the doctor, there's nothing to worry. Again, he attributed it to the to my age.
Mhm. In your PDS, you wrote that you have been consistently applying continuous trial rules in criminal cases before its passage. Is that true?
Yes, sir. I
Oh.
resolved my cases speedily. That's precisely the reason why I only have uh, now I have 100 plus only criminal cases.
How is that, Judge? You only have
100 plus insofar as my
100 plus?
criminal cases, sir.
Okay, so you must have a complete set of prosecutors and public attorneys there.
Yes, luckily I have two prosecutors, one POW also, sir.
And you are holding criminal hearings every day?
Yes, sir.
Okay.
I mix it with my civil as well as my criminal. That's the reason why I lowered down my docket insofar as criminal cases.
Okay. You listed also a considerable number of credentials consisting of the awards you received from several affiliations. Do you think these credentials would, in a way, boost your chances for a promotion?
Hopefully, sir, I hope it will be considered.
In what way and how?
Well, that means I am credible, I am competent, and I exhibited integrity, independence in my work, sir, as a judge.
In the criminal cases under your docket, do you have a number of cases involving CICL,
Yes,
children in conflict with the law?
yes, sir.
And in your 11 years of service in the judiciary, were the causes of the what could you say of the high number of juvenile delinquents or CICL?
Actually, sir, not that much. CICL. I have cases, but some are adults. But the victims are minors. But CICLs only few cases of CICLs.
Okay. Your court is a general one or a
Not
specialized court?
specialized court, sir.
Uh, Family court?
Yes, sir.
Okay. So how many cases have you heard involving petitions for the annulment of marriage?
A lot also, sir.
And how would you compare it to a bill pending in Congress, the divorce bill, assuming that it will be passed?
I I also agree. I want it to be faster because of the experience in my courts that there are so many irremediable marriages already that really you can reconcile already these spouses, and it will just cause harm, undue sufferings to the children if they continue to live together with such, I mean, abusive relationship like that. So I believe it's high time for us to have the divorce law in our country.
In your personal view, which between the two would be uh, would have a lesser ground for dissolution of marriage?
In It's very difficult to secure declaration of a favorable judgment from declaration of nullity because the only ground there is psychological incapacity. But
No, there are many. There are many. Aside from psychological incapacity, di ba?
yung Article 36, sir, mostly Article 36. However, under the bill, I don't know if I read it correctly, parang if they've been living separately for a certain number of years, that could be a ground. Or if one has been convicted or accused of something, of a crime, then that would also be a ground. So it would be probably easier for the spouses to free themselves from such marriage.
Now, should you be promoted, what judicial camp of ideology will you pursue in deciding cases? The conservative one, the one that believes in the originalism, or the liberal, believing in a living constitution?
I would go for originalism, that in interpreting the, I mean, statements of the Constitution, then you go back to the understanding of the Constitution at the time it was adopted. I would go for that, sir.
Now, under the amendments to the 1997 Code of Civil Procedure, claims are being asserted in a complaint to which an answer is filed. Now, under this amendment, can an answer be responded to by a reply?
As a rule, it's prohibited, Your Honor, unless an actionable document has been attached in the answer.
Okay. What then is an actionable document?
An actionable document is one that it would present documents evidencing the claim.
So, in what way can an actionable document be pleaded?
Well, it can be pleaded into the complaint itself, or it can also be pleaded in the answer. So it can be pleaded in the reply, and then rejoinder would be filed if there is an actionable document pleaded in the reply.
Can an actionable document be pleaded by setting forth the substance of such document in the pleadings and attaching the document as an annex?
Yes, sir. Actually, you have the choice. You can state the main the main contents of that document in your complaint, or refer to the attachment also.
Now, what are the defenses that a defendant can interpose?
As to the defenses, well, first, sir, a defendant can file a motion to dismiss. However, there are only 4 grounds for the motion to dismiss, like litis pendentia, res judicata, statute of limitations, and the lack of jurisdiction over the subject matter. Other grounds, you can only allege it in your affirmative defenses, sir. You can
What
also,
about
yes,
affirmative defenses?
yes, sir.
Now, in resolving affirmative defenses, what is the period for the court to resolve the same?
Period. Affirmative defense. I think 15 days, Your Honor.
Review further, it's 30
30.
calendar days.
30 calendar days. I'm sorry.
Okay, let's go back to the reply. What is the effect if no reply has been filed despite the fact that the answer had attached an actionable document?
You're deemed to have admitted the said actionable document, sir.
And can a defendant file a rejoinder?
Rejoinder is prohibited, sir, unless in the reply an actionable document has been pleaded.
Correct. Under the amended Code of Civil Procedure, what must every pleading include? There are three.
Pleading? What? That's not intended to harass?
Yung contents of the pleading.
It must it must contain not only the ultimate facts, but you have to include also the evidentiary facts.
Okay, that's one.
Okay. If it is a verified pleading, there must be a statement that is not intended to harass, to delay, cause unnecessary increase in the expenses, and that it is supported by the allegations are supported by evidence.
Yung names of witnesses, are you familiar with this?
Yes, Your Honor. Well, of course, you have to include also the names of witnesses, state the testimonies of the said witnesses, attach judicial affidavits.
Ayun naman pala. Alam mo naman pala eh.
Sorry, sir.
Now, can a party present a witness who has not been named in the pleading?
As a rule, no, sir. Unless, probably in the interest of justice, if you ask the court and it was granted, then you could.
Mm-hmm. As a rule, substantial amendments can be made with leave of court. Now, can a court refuse to grant such a request?
Yes, sir.
Yes, it can. For what reason?
If it is intended only to delay and then to confer jurisdiction when there's no jurisdiction, or if the complaint doesn't have it fails to state a cause of action, then you cannot amend.
Mm. Now, what are the different kinds of the modes of service under the amended Code of Civil Procedure?
Well, first, personal service. You can have substituted service. You can do it by registered mail. You can do it by facsimile. You can do it by email. And then you can also have it by extraterritorial service of summons.
And what is, give me an example of an extraterritorial service.
Apostille.
What is that all about?
It's a form of authenticating. It's a form of authenticating a document for use, for foreign use.
Okay, how do you effect personal service?
Personal service, the sheriff will serve the summons, sir.
To whom?
Defendant.
To whom?
To the defendant first, sir.
Mm-hmm.
Now.
That's all?
To the defendant. And in case the defendant is not around, that it can be done by substituted service. You can leave it to a person of sufficient.
You are going further. You are going further.
Yes.
We're just on the personal. Yung, how is it effective?
If he refused,
by personal delivery of a copy.
Yes.
To the party or to the party's counsel. Or?
Okay.
Marami yan. Sige. Kindly ko na lang dyan, ha? Just study further the amendments, no?
Yes, sir. Yes, sir.
Okay. So let's go to Rule 42. or Rule 43, which is an appeal from quasi-judicial bodies to the Court of Appeals. Are you familiar with this?
A little. A
Huh?
little, sir.
Okay, a little. Okay. Are the commercial arbitration awards reviewable under Rule 43?
Yes, sir. Pasay.
Yes.
Arbitration awards.
Uh-huh.
SIBA.
Mm-hmm.
Appealable. Under Rule 43, sir.
Yeah. Commercial arbitration awards.
Commercial arbitration awards.
Oh.
I'm not familiar with the commercial arbitration awards, sir.
You are not familiar? Then let's skip this one.
Yes, thank you, sir.
What about the remedy of an aggrieved party from a decision of the ombudsman in an administrative disciplinary case?
Yes, you can. You can file a petition for review under Rule 43, provided it only pertains to administrative cases, sir.
Okay. What if it is a criminal case? What
If it
is
is
the remedy of the aggrieved party?
go to the Supreme Court. If it is non-administrative as well as criminal, Supreme Court.
Under what process? Petition?
Appeal, certiorari.
Petition for certiorari. Yeah. What about the remedy if the ombudsman exonerate respondents from an administrative liability?
No more. You cannot appeal anymore.
Cannot appeal. Is it not that the proper remedy would be under Rule 65?
But I think there is a provision there that in case of the if there's grave abuse of discretion, Your Honor, otherwise you cannot appeal it under Rule 43.
Under Rule 43, you can no longer appeal from it because it's a final and unappealable. But the proper remedy would be Rule 65.
Yes.
You have been with the judiciary for almost 20 years or 15
No.
years?
15 years, 16 already. 15 years, 15 years.
15 years. So how is your relationship with your staff?
Well, I would say, we go along together. We help each other. We are like a family.
How about your peers?
Same with my peers. I was the executive judge for 6 years, and no problem with my colleagues.
Are you receptive to criticisms, whether it be constructive or destructive?
Yes, sir. But if it would help you improve, then it's okay.
So how is your personality affected by criticisms?
No, I'm not affected. I'm not. I am affected in the sense that it would serve as a lesson for me.
Mm-hmm.
But to be emotional or whatever, I am not.
But there are times when you become excited, and times you become sad, and this somehow has affected your propensity for a good judgment, diba?
Oh, but it's normal, sir. But for as long as you control it, it's not too much. Then you're just a normal being that you get excited sometimes and you get depressed for a while. For as long as it will not take you long to be depressed or worried about something.
Okay, Judge Carey, what is it in you that could convince us in the JBC to help you get promoted to the Court of Appeals?
I well, my work experience, my work habits, my passion for my job, my love for my job, and really my desire also to excel in whatever undertaking I do, sir.
Mm-hmm. Some more?
Well, my credentials, Your Honor, as per my PDS, I was recommended also by the IDP, and then the RR, I mean Juvenile Justice Committee. Also, my scholastic records from elementary up to college. I graduated as cum laude in my Bachelor of Arts, sir.
Did you earn some citations during your school days?
Yes, sir. As I've said, I graduated cum laude. Then my elementary, I graduated salutatorian. Secondary, I graduated valedictorian.
Other than that, wala na.
No more,
In
sir.
college, the School of Law.
I'm not active, so that's it.
Oh. Do you believe in leadership by example, Just Kari? I'll
Yes,
call you Kari, huh?
yes, sir. Thank.
That's
Precisely
why.
what.
That's why instead of calling Attorney Tali, I called her Attorney Kari.
Yes, sir.
Okay, sige.
That's precisely what I do. I lead by example. That's why my staff are doing their job well. So I have no problem with them. They know that I am hardworking, that I need to finish my job within the prescribed period, and so they follow also.
Okay, Judge Kari, it was nice talking to you again. So that was my last question. Good luck and stay safe.
Thank you, sir. Stay safe too.
Thank you,
Attorney
Judge.
Tali,
Thank you, Judge De
thank,
Monteverde.
thank you likewise, Attorney Tali. Ha?
Yes, po. The,
Sige.
the next interviewer is Honorable Justice Noel Jimenez Tiham.
Good
Thank you,
afternoon, sir.
Ali. Good afternoon, Judge.
Good afternoon po.
You answered all of the questions. You came prepared. What subjects did you not prepare?
Please ask me the subjects where I prepared so I could answer you, sir.
It's late in the afternoon. I'll just ask a few, very few questions, so that the other members will have time to ask the questions. All right. Hypothetical. Hypothetical. And by the way, I think there's a new, if I'm not mistaken, there's a new presiding justice in the Court of Appeals.
Oh,
Uh, in the Canadian province of Quebec in Canada, they passed a law prohibiting the wearing of religious garbs by some public servants, those who are working in government, like teachers, lawyers, police officers, and other government personnel. So, for example, the Muslim women, they were barred from wearing the hijab. Okay, the Jewish men, the kippas, and the Sikh men, the turbans. And a petition was filed in Canada assailing the constitutionality of that law. Supposing that same law is enacted here in the Philippines, and the constitutionality of that law is also questioned and it is raffled to you, how would you decide that case? There are no right and wrong answers. I'm just interested in your opinion.
well, sir, applying the benevolent neutrality rule, probably that that would be. I mean, that's we can accommodate the free exercise. I mean, in the exercise of the freedom of religion, they could, or that's valid and constitutional.
So there is there is nothing wrong about regulating the wearing of religious garb by public servants, those who are working in government. So, for example, if there is a law that will prohibit Muslim women from wearing the hijab, wherein they cover their faces, or the Sikh men using turban, people from India, for example, do you think that that law would be valid or it would be invalid?
I that would not be valid, Your Honor.
It will not be valid.
Yes.
So you're saying they should be tolerated to wear their religious garb while in office in government.
Yes, sir.
So if there is a law prohibiting that, that will be unconstitutional.
Yes, sir, because you would be violating their free exercise
Constitutional,
clause, Your Honor, the freedom of religion, sir.
what constitutional right is violated?
Equal protection.
Equal protection clause. All right. Uh, you've been following up the U.S. elections, correct? The elections in America. Who are the candidates?
Of course, Trump and Biden, sir.
Not research on that.
I did not research on that. I have no time for that, sir.
Biden and Trump. Okay. The president of America now is President Donald Trump. And he spoke on national television to complain about alleged massive electoral fraud. Now, the news agency covering the president thought that he was telling a lie. He was making a false claim. So they suddenly stopped broadcasting his speech. Do you think that's proper? Is that valid? Is that constitutional?
Uh, it's
So
not valid.
imagine that the president of the Philippines is speaking before national television, and then the newscasters, the news agencies, believe that what the president is saying is false. Can the news agency, do they have the right to stop broadcasting the speech?
No, sir. That would be violation, in violation of the freedom of speech, of freedom of expression, especially coming from the president. I mean, President Trump is still the president right now.
So you think it is illegal for news agencies to stop broadcasting the speech of a president whom they consider to be saying something which is false?
Well,
They cannot
well,
do that.
well,
They cannot do that.
yes, if President Trump was rendering his speech on an official occasion, for instance,
Officially,
public.
the president, he appeared before national television. There is the presidential seal on the rostrum. So he's speaking, he is saying there were electoral fraud committed by my opponents. Now, the news agency covering him suddenly stopped covering him because they thought that he was making a false claim. So, in other words, you're saying that news agencies cannot stop broadcasting the speech of the president even if they think the president is saying something false. Is that what you're saying?
Yes, sir. Unless it's a private broadcasting agency, in which case, I mean, it's up to them whether to post or to broadcast, allow the broadcasting of something, sir.
All right.
But doing it on their own,
So, is there a constitutional right? Does the president have a constitutional freedom of expression?
President. Yes, not only the president, even
No, the the question is about the president. You're straying away. You must have reviewed a lot of subjects. Okay, so we're only talking about the president. Does the
president.
president have a? Is he entitled to freedom of expression, freedom of speech?
Yes, sir. He's the president. So more so that he should be entitled also to the freedom
So
of speech.
anybody, any Filipino has the freedom to speak, even if what he's saying is false. That's what you're saying.
What, sir, it's like this. We have the so-called freedom of expression. You can make a speech, but if the speech you make or the message you make constitutes violence, threat, for instance, or it involves pornography, obscenity, inciting to the commission of a crime, probably, then that would be
So you're saying media media is permitted to stop uh, covering or broadcasting the speech of the president because they disagree with the speech of the president. Is that what you're saying?
no, I don't agree to the stoppage of the broadcasting, sir.
All right. Let's go to another topic. Recently, the director of the National Penitentiary in Muntinlupa ordered the mandatory removal of tattoos. You know what a tattoo is?
Yes, sir.
Of PDLs, persons deprived of liberty inside the National Penitentiary. So the question is the mandatory, you know what mandatory is? Mandatory removal of tattoos from inmates in Muntinlupa, is that valid? Is that constitutional?
It would depend on the purpose. I mean, what's the purpose? What's the reason behind that mandatory, uh, I mean, removal of the tattoo, sir?
So explain your answer.
So, so it would depend whether it is necessary for what public safety or whatever. Otherwise, they cannot because it pertains to one's person life.
What,
What he
what
wants to do with his
constitutional
person.
right is violated? The right to have a tattoo? Is that in the Constitution?
But a person has the right to do whatever he wants to do with his person, sir.
Now, the director of the National Penitentiary explained that the removal of the tattoo was to eliminate the identification of gang mates. In other words, they wanted to integrate all of the inmates. So there is no more segregation of those belonging to one gang and another belonging to other gangs. That resulted in the past to many fights and even killings among gang members. So that's a very noble objective. Does that make the order, the mandatory order of removing the tattoo, valid and constitutional?
Well, under that circumstance, I agree that they could regulate. I mean, they could regulate these PDLs. They have a noble purpose, sir. So, in the exercise of their power to regulate, supervision or whatever, then they could do it.
Okay. Uh, you have children, Judge? You have children?
Yes, I have four, sir. Four.
Yeah. Or do you discipline them?
Yes, sir. But not too much because two of my children are now lawyers, sir.
With more reason, you should discipline them, correct? Because they're no lawyers.
They can no longer control them, sir. Because they have a mind of their own, most especially that they know the law. I mean, they tell me that, well, we know the law now, so that's it.
Do parents have the constitutional right to discipline children who are discourteous, who are disobedient?
Yes, sir. You have the right to discipline them for as long as you do not inflict abuse, I mean physical harm, violence on your children, because
Do
otherwise
parents, do
you could be
parents have the
subjected.
right? Do parents have the right to sue their own children?
I in that case, Your Honor,
To
well,
legally sue their disobedient children?
but what would
So if
be,
you say yes, what is your constitutional basis? If you say no, what is your constitutional basis?
depending on the crime committed by the children, sir? It would depend on what did they do, because if you discipline them, I mean, why would you sue your children?
That's the first advice given by professors to those taking the bar for the first time. If you're not sure of your answer, you distinguish. All right. My last question is this. You're a judge. You're familiar with the power of judicial review.
Yes, sir.
In layman's term, what is a justiciable question and what
Just
is a political question?
political question, it involves the other branches of the government political, it involves their wisdom, their policy. If it is justiciable, well, it is subject to review by the judiciary.
The anti-terror law is being questioned before the Supreme Court. There are about 37 or 38 petitions. In your opinion, all right, there are no right and wrong answers. Does it involve a justiciable question or a political question?
There are, as per my reading, sir, there are provisions in the said anti-terrorism law that could be reviewed by the Supreme Court, like the warrantless arrest. The upon order of the Anti-Terrorism Council, a written order, they could order a law enforcer to arrest a person and detain him for a period of 14 days and extension of 10 days, 24 days without even the filing of a charge. So that would be a violation of arbitrary detention, right against. I mean, it would be a warrantless arrest. So you have the right. I mean that would be a violation,
All
sir.
right, you answer this question, I'll vote for you. What is the doctrine of judicial or constitutional avoidance?
Is that I think it's similar to judicial restraint.
Explain.
Okay. Uh, as a rule, okay. As a rule, sir, if you can avoid not not discussing or ruling on the constitutionality of the whole law, then do not. But if there are provisions, you can have it partially rendered unconstitutional. If you exercise judicial restraint, I mean, there could be instances when you exercise judicial restraint, like avoiding declaring the constitutionality of the law because you respect
So
separation of powers.
you're saying they're the same, judicial restraint and judicial avoidance. Do you think the Supreme Court can apply the doctrine of judicial or constitutional avoidance in resolving the petitions relating to the anti-terror law?
Uh, the, the Supreme Court has the constitutional duty, Your Honor, to resolve cases brought before them. And
Supposing they're busy, can they toss it to the lower courts or to the Court of Appeals?
well, it depends on whether the petition is of transcendental importance. It involves questions of law only, sir. Then they have no other option, choice. They have no choice But
So
to
when can
it,
they toss it? When can they toss it to the Court of Appeals?
if it's probably if they would consider it as what do you call this, like declaratory relief because no injury yet, that would be the time probably that could toast it. But they have to dismiss it and it would be refiled probably with the Court of Appeals.
All right. I noticed that you are very anxious and excited about answering all of the questions. All right. Thank you very much, Judge, for your time and good luck.
Thank you, sir.
Thank you, Justice Tiham. For the next interviewer, Honorable Judge Ribio E. Ilaw Jr.
Good afternoon, sir.
Yes, good afternoon, Judge Caridad Villegas Galvez.
Yes, sir.
Already tired?
Yes, I am nervous, sir.
Still nervous?
Yes.
Gotta take a deep breath and smile. Smile naman, siyempre. Yun, good. Ay, mating yung
Sir.
mga panggalatok, ganyan talaga. Any relation to the retired General Charlie Galvez?
No relation at all, sir.
Okay. All right. Your application letter has grammatical error.
I noticed that, sir, and I'm sorry. I know. Because I copied that from the downloadable form of the JBC, and then I was not able to edit the last portion. I know that, sir, because I noticed also my error. Is and are. Sorry,
Also,
sir.
also your explanation letter and PDS as well. Is this your work ethics, Regal?
No, I'm no, sir. I'm just but human. I am just but human, and sometimes I commit error, imperfections, human imperfections, and I'm sorry, sir.
And
Because
don't make it.
and besides, sir, I was so in a hurry to finish my papers at that time because I got worried because I was told that it will take time before it will reach the JBC in case you send it by private courier. So I wasn't able to fully edit everything, sir.
I'll just a reminder that don't make it a habit to commit mistakes, Regal.
Thank you, sir.
All right, you likewise stated in your application letter that, I like quote you had been active in promoting to uphold the rule of law. What is your definition of the rule of law and how is it implemented in the current legal landscape?
Yes, sir. No one is above the law. All persons, regardless of their stature, citizens, and including the state is accountable to the laws, Your Honor. And we should all abide by the law.
And you likewise stated that you were awarded by the Department of Justice Witness Protection Program for your unsullied integrity, legal erudition, and selfless commitment. Could you cite specific circumstances wherein you were able to excellently exhibit these qualities?
Uh, the terms used there, I copied that from the certificate, sir. I copied that from the certificate issued by, I mean, in the certificate given by the DOJ. I mean, I was given twice a certification, sometime 2010 and 2017. But the reason why they gave me that is because they believe in my integrity, in my work, Your Honor, because I convicted the accused, uh, there, despite the fact that the accused has probably, I mean, they're known in the community.
Your sala is a court of general jurisdiction, Judge?
No, sir. It's a family court.
In family court. Likewise, you explained that the discrepancy between your SAL N and PDS is due to a BDO savings account that belongs to your husband intended for your emergency needs. Why was that account not declared in your SAL N?
No,
Is this a secret account?
I declared it in my SAL end, sir. It's in my SAL end. Yes. Okay, sir. I have to explain
So
that.
it's not declared in your SAL N.
No, the total amount, sir, it increased because that is an or account, Your Honor. It's or account. So, and that was being maintained by my husband. It's not an and or, but rather it's or account, sir.
Your husband is, what's this? Edgardo C. Galvez.
Yes, sir.
Is also a lawyer.
Lawyer, sir. He practices also his profession. Aside from being the vice president of the Surety and Legal of Fortune.
Okay. What again was your explanation that this account is not declared in your SAL N? Admittedly, you...
No, I declared it, sir. But it just increased the amount. It just increased the amount because he was the one maintaining that.
Alright, you mentioned that you had been with the judiciary for almost 15 years, Judge.
Yes, sir.
And what have you accomplished and what changes have you effected in your position so far?
Changes. Well, I continuously apply the rules, the rules, sir, like the continuous trial rule. Right now, even during the pandemic, I hold hearings, sir, face-to-face trials, notwithstanding the risk that we have to take. Because I am aware that not all litigants could afford to have an internet connection. That's why I still continue conducting hearings face-to-face.
And what do you consider your greatest contribution to the judiciary? This is a given question.
Judiciary. Well, I dispense justice by speedy disposition of cases. I provide access to justice to all. And then I also, with the decisions that I make, which is just, which are just, fair, and equitable, then I'm promoting public trust and confidence in our judicial system.
You have been in your present position for a long time. There is a saying that those government employees who have been in their positions for so long are already lax and no longer have motivation for improvement. What can you say about this?
I cannot afford to be lax, Your Honor. I need to work. I have to comply with my obligations. So not necessarily lax. The more that I have to work in order to dispose cases, Your Honor.
All right, you're applying as an associate justice of the Court of Appeals.
Yes, sir.
Can you discuss the reorganization of divisions in the Court of Appeals?
Sir, I am not that too familiar, but I know
But
that
you're
there
applying.
are,
Yes,
with the
please.
divisions, but there are 68 justices, associate justices, one presiding justice. Then there are 23 divisions with two members and one chairman. And then, of course, they follow precedence. And in case that there would be no unanimous vote in that division, then it could the chairman could write a letter to the raffle committee, and then the raffle committee would include two more members like that, sir.
You went too far, but the question is with respect to reorganization.
So, sorry, sir.
All right. Reorganization of divisions happens in the Court of Appeals whenever a permanent vacancy occurs in the chairmanship of a division. Are all members of a division required to be present at all hearings of the division at all times?
Well, it's supposed to be, sir, but in case of justifiable absence, then they may not be able to attend.
And what is the certification required to be issued by the Court of Appeals?
I'm sorry, sir. I'm not familiar with that.
And then this is the 2009 internal rules of the Court of Appeals. At any rate, let's go to another topic now. How could the cost of judicial administration be reduced?
Costs. Insofar as our court, sir,
Yes, please, sir.
well, cost of judicial administration. Right now, sir, we are given already our respective budgets. So in which case, we are able to control what are the needed items in our office. So we could, and also we buy what we need. So in which case, that would, of course, reduce the costs. Unlike before, they give us whatever is available. I mean, the request is different from the supplies that they give us.
How do you maximize social as well as media in your sala or the entire judiciary?
Well, I don't engage too much in social media. Social media as a platform would be advantageous sometimes as information, dissemination, or communication. But when I use social media, I remain to be a judge. I mean, I should not be engaging too much because that will be exposing also your privacy, as well as, I mean, if you post pictures and everything, that would expose you to danger also. So whenever I use media, it's just for a little social life, as a form of distressing, but not totally, I mean, devoting so much of your time in social media.
What are your thoughts on magistrates who are fond of conferences and media?
Well, publicity undermines dignity and impartiality. So, well, I can say anything to them, sir, because that there's their personal conviction. I mean, if they prefer to use social media. But I, for one, speaking for myself, I don't want to engage too much in social media.
Are you a computer proficient judge?
Not that much, but I make my decisions direct in
Direct?
my lap. I mean in the desktop, so I could research, copy paste, and everything. So a little computer literate. I've been doing that. I use the computer direct in drafting my decisions.
Do you avail online resources in the legal research?
We have eLib, sir. So I use that. It's very useful, e-library. Google, sometimes you can use it also in your research.
Right. So you will agree that magistrates and lawyers as well should be abreast of recent legal developments.
Of course, sir. Yes, sir.
You are a presiding judge of a family court.
Yes, sir.
Are you familiar with this case? The court recently promulgated its decision regarding same-sex marriage. Could you discuss the court's decision?
It was struck down, Your Honor, same-sex marriage. First, it was premature. There was no actual case or controversy. And then, according to the decision, there are so many laws already, but he never mentioned or detailed those laws and just concentrated on this law between marriage between a man and a woman. So the Supreme Court said they cannot encroach on the powers of the legislative because that is of course legislating an act that would be an encroachment on the power of the Congress.
All right. What are the guidelines on the imposition of interest as further modified for clarity and uniformity by the court just last year? Are you
Yes.
familiar with this case?
Not the
Lara's
interest
Gibbs?
because I'm not that familiar, Your Honor, but because I just follow the 12%, I mean the 6% interest. That all damages would be subject to 6% interest.
In a recent case, the court likewise declared an ordinance imposing speed limits unconstitutional. What are these prerequisites for an ordinance regulating land transportation and traffic rules to be valid and enforceable?
I'm not that familiar, but I just make a guess, Your Honor. There should be, I mean, equal protection clause should be applied. There must be a valid classification. There must be no discrimination.
All right, Judge, what is the greatest injustice you've lived through?
I lost. I lost when I ran as vice mayor. I lost when I ran as vice mayor. So I had I mean, noble intention in running. I had good plans, but I lost. Well, but of course, I mean, that's my own feeling, sir.
Do you call that injustice?
No, not really. It's not injustice, but it's just that uh, uh, I mean that's the decision of the electorate, so I cannot do anything.
All right, my last question, Judge. If you were to be deserted on an island and given the chance to bring three things, what will you bring and why?
Island deserted. I want to bring my family, my
You,
husband.
you're going to bring you what?
I want to bring my husband, my children.
That's two. Oh. And
Uh,
lastly,
and lastly, I want to
your
bring.
mother-in-law.
I want to bring my phone.
Your phone.
Yes.
Why?
I mean,
Explain.
I want to bring my phone so I would be able to tell everyone what happened to me, or what happened to me on that certain period of time. I mean, I would be able to make a memory, out of that.
An island with no signal, you're going to bring your phone.
If there's no signal, then I'll just bring my rosary, sir.
Rosary. Okay. That was my last and final question. Thank you, Judge, and good luck.
Thank you, sir.
Nervous ka pa rin, patapos na. Okay.
Wow,
Thank
sir.
you. Good luck.
Thank you, sir.
Thank you very much, Judge Ilaw. The next
you.
interviewer is Honorable Justice Jose Catrell Mendoza.
Good afternoon, sir.
Okay, good afternoon,
Good afternoon,
Judge
sir.
Galvez.
Yes, sir.
Justice Mendoza, can you start your video, please?
Oh, prines ko nga, ayaw. Ayan,
Good afternoon, sir.
good afternoon. Oh. Judge Galvez, you covered, my colleagues covered so many areas. So wala na natira sa akin. Okay, you are applying for the position of Associate Justice Court of Appeals. So, you have been in regional trial court judge for 11 years.
Yes, sir.
When you were in the it appears from your records that you were administratively charged twice. What are these cases?
When I was an MTC judge, the first one involves a lawyer who was the respondent. During that time, sir, we MTC judges conduct preliminary investigation. I recommended for the filing and then pass it on to the prosecutor's office, and they affirmed my resolution. And so they questioned that, sir.
I see. By charging you with ignorance of the law?
Yes, but I wasn't.
That was Joaquin Reyes, filed by Joaquin Reyes.
I know
Or
the other one, sir.
Glendale.
Glendale, sir.
Yes, that was the complaint
The
was
lawyer.
harassment.
Yes, sir.
Why were you charged with harassment? The charge was harassment.
Glendale, sir. Glendale.
Yes.
Okay.
Oh.
That's why, sir, I was referring to that case wherein the respondent is a practitioner, a lawyer, sir. So I wasn't contented with my resolution, but I was not the one who filed the information. It was the prosecutor's office. I just conducted preliminary investigation because we MTC judges were required to conduct PI then, although now no more. So I filed it. So the wife filed a case against me, but I wasn't even required to comment on that, sir. It was dismissed immediately.
Without your comment?
Yes, sir.
Oo. In OCA IPI 1870, you were charged by one Joaquin Reyes for ignorance of the law. What law did you allegedly ignore?
Well, sir, that was a case. I was a newly designated judge in that court, and then what did I do? A decision was rendered by the former judge who retired, and then I came in. A motion for recon was filed, and then I resolved it. It just so happened that what did I do? I acquitted the charge. You know, that person, sir, the one who filed the case, is a well-known personality, and I didn't know about it. he filed cases.
No, my question was, what law did you allegedly ignore?
Because according to him, sir, since
Yes.
since I wasn't the one who heard the case, then I should not be resolving the MR.
I see. Okay. And both cases are already dismissed, right?
Sir, actually, he made it difficult for
In
me when I.
your uh, SALN, excuse me, in 2017 SALN, you you claimed to own a Montero worth 1,200,000 and a Fortuner 1,500,000 and another Fortuner 1,500,000. Why is it that after a year, the Montero you valued at only 300,000, the Fortuner 500,000, and the other Fortuner 2016 800,000? What was your basis? What is your depreciation formula? Because it's very there is a big difference between the 2 years.
Yes, sir. My Montero is a 2009 model.
Yes. It says here in 2017 you declared it as having the value of 1,200,000, and then after 1 year it lost 900,000. It became only 300,000.
Okay.
What was your formula, depreciation formula? Because the government uses the 7-year depreciation. In your case, in 1 year, it becomes percentage.
Yes, sir. Because that was the acquisition cost. I mean, I previously used the acquisition cost until one time a judge told me that I could use the market value. That's why I changed it into the prevailing market value, Your Honor, because in order to reflect the true assets. But
the
before
the true value.
Yes, sir.
In 2017. So in 2018 you reflected the depreciated value.
Yes, sir.
In 2017 the values you mentioned were the acquisition value.
Yes, sir. Yes, sir.
Okay. And again, my question was, how did you arrive at this depreciated value? What was your formula?
I don't have the formula, but rather I base it on the actual because someone is
actual.
Yes, sir. Because of the age of my car, and they will not really buy it for such amount already. I just
So this is only an estimate.
Yes, sir. Yes, sir. Estimate.
Estimate. So no real basis. No formula.
I asked it from my husband, who is also in insurance.
I see. So it is your honest to goodness basis. You are in good faith in estimating it. Then
Yes, sir.
yes. So earlier I was listening. You mentioned the benevolent. What was that? Benevolent.
Neutrality.
Are you sure that was the accurate term? Estrada versus Escritor.
Yes, sir. I in that Estrada versus Escritor,
Yes.
The Supreme Court gave some, ruled that there could be.
The term used was benevolent, neutrality, what?
Benevolent neutrality rule or principle.
What did you mention? What did you mention earlier?
Benevolent neutrality rule, sir.
Oh, anyway, it's close. Benevolent neutrality doctrine.
Doctrine. Yes.
Oh, yes, it's all right. Oh, it's also called benevolent neutrality theory. Oh, can you expound on this?
Okay. Do I have to state the case, sir? I am familiar with the
What
case.
What?
I
No,
mean,
I'm not going to ask you about the case. There are two, Estrada versus Escritor. I will not ask you about that case or
Okay.
even the RH law. Oh,
Okay.
you were invoking this doctrine or theory in the law against the use of hijab, right?
Yes, sir.
Earlier, did I hear you right?
Yes, sir.
Oh, what was your answer earlier?
I said that there could be certain accommodations on the ground of the free exercise clause, the exercise in pursuant to the freedom of religion, provided there's no compelling state interest.
Suppose the compelling state interest is national security.
If it is a national security, then that would be a valid.
Is that a compelling state interest?
Yes, sir.
How do you define compelling state interest?
If state interest, if it would endanger it would endanger the state. If it would endanger the state, sir, that's something to do with.
What are the interests of a state?
Interests of the state, like interests of national security, public welfare.
I gave that earlier. Oh, security.
Security, yes, sir. Public welfare, public
Yes.
health.
Oh, no. I'm the one asking. You're asking me if public health.
Yes, sir. National security interests of. I mean, I am answering, sir. I'm guessing because I am not that.
You're not sure.
I'm not sure.
You're not sure. Okay. What is the constitutional provision on the right to travel?
The right to travel. The constitutional provision. A person shall be no law shall be passed. I mean, a person is entitled to his right to travel, but it could be limited, sir. It could be regulated.
Are there statutory limitations or merely constitutional limitations? Are there constitutional limitations?
Constitutional. Yes, in the interest of national security, public welfare, and public health. Those are the constitutional limitations, but there are also statutory limitations.
Yes.
Of the right
What are those?
Like Adoption Act, Human Security Act, Trafficking, Violence Against Women, Passport Act, and the Immigration and Workers Act.
I see. What else did you cover earlier? Yeah, you mentioned the interest. That was the decision in Lara's gift. What is forbearance of money?
I am not that familiar of interest, but forbearance, it has something to do with.
But you're teaching obligations and contract.
Before that was no,
you
I'm
did not teach forbearance of.
That was long time, sir. I did not teach. I am not teaching obligations and contracts.
It says here you thought obligations and contracts at the Guzman Institute of Technology.
That was when I was not yet a lawyer.
Not yet a lawyer, but you cannot remember. Oh, what did you teach there? What is forbearance of money or credit? Anyway, you said you read the latest cases, you know. that was spent that Lares gift was spent by Justice Carpio, who retired. So it is a recent decision. What is forbearance of money?
The value? I am not that familiar. I have to admit, sir, I haven't
I
read that.
see. Either
I'm not. I haven't read that case.
okay. Now, what was your pre-law course in UE?
Political science, sir.
Oh, political science. You can easily answer this. What is natural law?
Okay. Rule of right and wrong. It is not covered by a positive law. It could probably be from God, but it is something that we ought to know to be right and or wrong.
Not necessarily from God. You mean? Did you say that?
It is from God.
It is. Suppose you do not believe in God. Suppose you are an agnostic.
Even if you are an agnostic, you know what is right and or wrong.
How about an atheist?
As a human being, these are, inherent in the person.
Yes, correct. Oh, yes. You know what is, you can distinguish from right from what is wrong.
Yes, sir.
As man's understanding what is right and what is wrong. Are natural laws covered in our civil code?
Yes, sir.
Oh, what is the provision of the civil code regarding natural laws?
Okay. Probably it could be applied to the abuse of right.
No, no, not probably. I'm asking the civil code provision. You answered yes. Do not.
Yes.
Oh,
Yes.
do not. When you say yes, you say do not start with probably.
Okay. Sorry, sir. Sorry. There's a provision in the civil code that every person must, in the exercise of his rights and in the performance of his duties, act with justice and perform act with justice.
Sir,
Perform
so you're referring to Article 19.
19. But I'm sure there is a provision, also another provision in the civil code, that is if there is no particular law providing for such, the natural law would be applied. Like for
Are you
instance,
sure? Are you sure? Are you sure of that?
yes, sir, we can apply natural law if there is no.
According to the civil code, you apply natural law.
No, it didn't state there natural law.
It says there that you cannot decline to make a decision, right?
Yes, sir.
In the absence of any law. Is that correct? Am I correct?
Yes.
And Article 19 refers to the human actions, right?
Abuse of right. Yes, sir.
Yes. Oh, I see.
Article 19.
Oh, your one's guide to in his conduct. Those are Article 19 and the other article are human laws. They are positive laws. So can you call them natural laws? They are based on natural law, right? But can you call them natural laws still? What is a positive law? What is a positive law?
No more. You don't call them anymore.
Oh, that's why I ask you what is the provision in the civil codes. Do not cite something which is already part of positive law.
I forgot, sir, but I know there is a provision there in the civil code.
You forgot.
Yes, sir. I'm trying to recall, but I couldn't.
And recall what you taught. Obligations and contact na naman.
Sir, 1980s. I taught that 1980s.
I see. Oh, 1980s.
Yes, sir. I cannot.
Okay. What is solution indemnity?
Sir, obligations and contracts.
Oh, what? You're applying in the Court of Appeals.
I am.
Oh,
The problem is when I am a family court judge, so I haven't.
no, because you're a family court judge, the more you should read other cases, not only those concerning the family court.
I will, sir. I will. I will.
Oh, you forgot it?
Solution DBT.
Yes.
At this point in time, I cannot think of it, but
You're tired already.
I am feeling nervous.
Oh, just relax. Oh, you're able to answer a lot of questions naman. Eh. Oh. So you mentioned earlier also the equal protection clause. Now, you stated the rule, and you said an exception is when there is a valid classification, right?
Yes, sir.
Okay. What is the test used to determine the reasonability of the distinction?
But if it is not discriminatory,
What is the test? Yes, it is a valid distinction. Eh. Listen first to the question. Maybe you're tired already. Oh.
yes, sir. Equal protection clause.
Yes. So, what is the test used? Oh,
Test use.
was written by the Chief Justice Bersamin in Mosqueda.
It must apply to all classes of the same kind.
That is the definition of the equal protection rule. Oh, I'm asking the test to determine reasonability of a distinction. Because you covered already valid classification earlier. So I'm not covering it now. So I'm going now to the test.
I'm sorry, sir. I cannot recall anymore.
Okay, it's the means and test. And then what are the three levels of scrutiny in determining a valid classification?
Okay, sir. Strict scrutiny test, intermediary test, and rational basis test.
Intermediacy?
Intermediary.
Intermediary? Do you know what's the meaning of intermediary?
Intermediacy test. Intermediacy test.
You know what is an intermediary?
I think, sir, if it doesn't involve fundamental human rights.
You review your constitutional law on that. What is sub judice rule?
Sub judice. When a case is already brought to the court, no one, the public, the press, the media is not allowed to interfere in the conduct of the proceedings or the
Interfere.
trial.
You use the word interfere?
Yes, no interference or
comment.
Yes, sir. Comment.
A comment.
Yes, sir.
Why did you use the word interfere? Why will they interfere?
No. They should not be. They should not be making comments, publications that would prejudge the case, that would influence.
Is that not a violation of the freedom of expression provision in the Constitution?
No, sir. Because
Why?
this. Because
can you prevent a columnist from commenting on a case?
Actually, sir, we cannot prevent them from.
You cannot. Oh.
we cannot prevent them from commenting. They could comment, but we could issue an order.
You can stop a columnist. He's not a party.
Is that a party?
Oh, can
But
you issue a gag order?
If that would be necessary in the administration of justice, then we could issue a gag order. However, sir, if that publicity would also be guarding against miscarriage of justice, then
You're a judge. Will you be influenced by comments
no, sir.
from the outside? No.
Definitely no, sir.
Have you issued the gag order?
No.
No.
Never.
Have columnists or pundits or newsmen commented on a pending case, a case pending before your sala?
None, sir. There was never.
Okay.
I mean, I can't. I'm not aware that they made any comments in my sala pending case.
Now, what are the two essential elements of the freedom of expression?
Freedom from prior restraint and
Yeah.
freedom from subsequent punishment, sir.
No, you're asking me.
Yes, sir. Yes, I am answering.
You are correct. You are correct. You are correct. Because you answered in an interrogatory form. Oh. And how do you keep yourself abreast with recent laws and jurisprudence when you are concentrated on family laws?
Well, I also read cases, sir. Notwithstanding that my cases are of family cases nature, I also read.
Okay, very good. Are you familiar with the case of People versus Sapla?
Yes, sir. Yes, sir.
And are you familiar with the ruling in Saluday?
Yes, sir.
Did Sapla modify Saluday?
No, sir.
No.
The same. They use the same principle. The need for probable cause. Before.
How about? Oh, this is easy for you. You can easily answer this. So, because it looks like you're very tired already. Oh, what is the crime of economic abuse?
Economic abuse, well, that's a provision in RA 9262, sir. If
Yes.
one makes or attempts to make the woman financially dependent on him, okay, distraction of property, household property, you prevent her from exercising her profession, you deprive or threaten her to be deprived of the financial resources of the spouses. I mean, or you prevent her also from making use of her own money. You prevent her also from using the conjugal financial resources. Sir, financial resources.
You can easily answer it. But why only against men?
Well, that is what the law is. That
Yes.
is what RA 9262.
Oh, you agree? You agree with the law?
Actually, sir, no.
No. So you disagree with the Supreme Court decision that
No,
there is no.
My own opinion, sir. My own opinion.
Your opinion. Okay.
But that is what the law is. I
Yeah,
mean,
so anyway, you can express your opinion. You disagree with the Supreme Court decision that the law is not discriminatory. Oh, you can express your own opinion. It's all right.
no. What I mean that I do not agree. It's not about the decision of the Supreme Court. What I mean is with the law, because it's unfair.
Unfair.
It's unfair.
Yes.
Because only men could be charged.
Yes.
And there are also instances where men could also be a victim of abuse from
So
the wife.
the law is discriminatory.
Well, as of now, there is no declaration that it is
Opinion, your opinion.
uh,
Discriminatory against men.
yes, sir.
Yes, di ba?
Because I have a lot of cases.
Can you not say that there is a valid classification?
Well, the Supreme Court decision say,
Are men, women different? Is there a
well,
valid classification
women in that
regarding economic abuse?
especially in economic abuse, because they say relying on the principle that, of course, men takes care of the family, of the budget for the family, the one working for the family, like that. But actually now, sir, both men and women are now working. So
The feminists will agree with you. Di ba?
yes.
What else do you want me to cover? You covered everything na ano. Oh, you do not like obligations and contract, ano? Oh. Sa Court of Appeals na lang, okay. What are the three general classification, categories, I mean, where the Supreme Court, the Court of Appeals is allowed to receive evidence? General categories.
In civil cases and in criminal cases for newly discovered evidence. And then for claims of damages on provisional remedies.
Provisional remedies. You forgot the first.
Si-
Where the court exercises original
yes,
jurisdiction.
annulment of judgments. Yes,
No,
original.
not only what are what are the original jurisdictions of the Court of Appeals?
Original jurisdiction. Annulment of judgment, sir.
Yes. What
Annulment of
else?
In petition for original with concurrent.
Oh, concurrent. Oh, hindi ko naman I'm not asking kung exclusive.
Okay.
Oh,
So,
that was the first category anyway. Parang you're tired na eh.
yes,
Oh, where the Court of Appeals exercise original jurisdiction, whether exclusive or concurrent, they
Okay.
can receive evidence. Okay?
Yes, sir.
Oh, you want more questions? No
No,
more.
sir.
No more? Oh,
Yes.
sige. Oh, sige. No more. You're tired. Are you the one suffering from bradycardia? No.
No, sir.
No, that's another applicant. Oh, sige. That will be all your.
Thank you, sir. Thank you.
Okay. Thank you very much, Judge Galvez. Thank you, Your Honors.
Pwede na akong leave?
Yes po, Judge
Pwede
Galvez.
na,
Okay,
oo.
thank you.
Opo.
Thank you.
That
Thank
ends
you
the
also.
Thank you, sir.
Thank you po. That ends the public panel interviews for today. Interviews will resume on November 27, 2020 at 9 a.m.